So the Canada Revenue Agency contacted me and looking for money, but I responded to them. My apologies. This is on July 3rd, 2024. My apologies for the delay in replying. I've had some family emergencies. I'm sorry for the briefness of our recent phone call, but I do get tired of telling my story over and over again. And hopefully now you have a more fulsome understanding of my personal position as well as that of Canada. I was placed in debt several $100,000 in a court action where the judge, whose fitness as a judge had been very seriously debated in Parliament, and who in my trial preferred the lie of the plaintiff to the transcript of a hearing several months previously in order to protect her lawyer committing fraud on a court order in a massive display of partiality to lawyers or plaintiffs or women. Financially, it was unreasonable to appeal the decision, and trust in the legal process was obviously completely compromised. I made a complaint regarding the judge's conduct because it clearly fit the description of judicial misconduct. Is the conduct alleged so manifestly and profoundly destructive of the concept of impartiality, integrity, and independence of the judicial role that public confidence would be sufficiently undermined to render the judge incapable of executing the judicial office? And everyone I talked to agreed that you can't have our judicial council approving of judges, protecting lawyers, committing fraud on the public, and using their client's opinion to settle the dispute and call that fair or impartial, and certainly not in compliance with the law. The Judicial Council approved of the conduct of the judge without even reviewing any evidence at all. I'll say that again. The Judicial Council approved of the conduct of the judge without reviewing any evidence at all, simply on the contents of my letter. Naturally, I did not feel this was an adequate examination and wrote back several times until I made a complaint about the judge, who dismissed the complaint, which requires that the opinion of outside counsel be requested. However, instead of doing that, the legal officer dismissed my complaint as an abusive process. I wrote to the Minister of Justice and informed them of the problem of the judiciary breaching the charter rights of Canadians, and how could we trust the legal system if we can't report criminal activity happening within it anywhere. I was paying for shelter with gardening work and struggling to keep my battered brain from being abused further. After 2 years of unrelenting harassment, 10 break-in entries, legal proceedings, and business collapse, the complaints that I had with the lawyers and their fixing of the trial by removing their self-incriminating evidence of fraud on trust accounts and failures to comply with court orders for trust account disclosure and much more were initially taken seriously by the Law Society, but suddenly their position changed, and the complaints were dismissed, and a refusal to provide written reasons as required by their governing statute was the subject of a complaint to the PC Ombudsman Office, who after a year of refusal by the Law Society gave up, saying that the Law Society promised to do so in the future. A report to the police similarly was dismissed, but I had followed all the formal channels and all the legal advice provided. Case fixing seriously compromises the public's trust in the legal system, and there is no method available to the public to report criminal conduct by anyone involved. I live a very modest life and have survived through the generosity of friends and family. Since that divorce, I borrowed money from clients to build back my business, but eventually failure to comply with some rules and regulations by me was the reason for seizing the last remaining asset that I owned and my entire life's work, and only means ever to pay back any debts that I owe. I struggled with depression from the hopelessness of the situation, and I'm sure my partner, later to be the mother of my children, at that time suffered too. It was brutal. For at least 4 years, I suffered severe PTSD and general dysfunction on many levels. BC Child Support Collection Services attempted to collect from me the child support that I had hired a lawyer 2.5 years previously to correct, and who never did. That was my first experience in 2005, being in contempt of court for failing to comply with child support, and I had presented evidence to the judge, who had declared that his income is now down to zero and lack of future prospects, but I cannot urge you strongly enough, sir, to get on with your application to vary that order. I had hired a lawyer, and he never did. After the trial, he wrote dismissing my complaint. If you find your income doesn't reach that level, you can hire a lawyer. Well, my income never did, and I never had enough money to hire a lawyer, but I did communicate with FMEP, the Child Support Collection Agency in BC, and provided them the details that I had provided the Law Society demonstrating the fraud perpetrated, and their decision was to delay collection activities for 5 years. That was the first acknowledgement that something was wrong and an effort to solve the problem. After 5 years, I was in no better situation, but I was a father to 2 little children that had started to restore my faith in humanity with the provision of and receiving of the love that children share with their mother and father. Being constantly broke, I was leveraging advance payments and short-term investment strategies with customers in order to stay afloat. And when COVID hit, I was neck deep in a massive effort to bring my operation up to regulations or face seizure. But at the same time, the government was threatening me with 80 days of jail for failing to pay child support, which my ex had initiated legal proceedings against me around the time I met a new partner and started an assault on the custody of the children. It's a small town. It's not pretty. One winter, she took the kids away for the winter, and I had resolved to hire a lawyer to resolve it, but the $10,000 I could raise didn't even start the process and left me in a worse situation than when I started. I had, however, served the Minister of Justice with the enforcement procedure of the Charter, Section 24(1), and taken the matter to court and publicized my experience online and in local newspapers. I presented the problem of a failure in the rule of law in the legal system, from a fraud by a lawyer on a court order to the judge protecting the lawyer to the Judicial Council protecting the judge and the Minister of Justice refusal to respond to the enforcement procedure of the Charter, requesting the matter to bring the matter to the only court of competent jurisdiction to resolve the matter, Parliament. I requested from the court a writ of mandamus, an order of the court for a minister to do his duty. The duty of the Minister of Justice is to protect the public and ensure that the administration is in compliance with the law. The standard or bar is very low on the balance of convenience. As it should be, a duty is the reason someone is paid from the public purse. A decision from that judge was due February 14, 2022, but she didn't do her duty that day either. She did not show up. But the Minister of Justice enforced the Emergencies Act on that day. Unfortunately, in my communications with the Minister of Justice, he had made some false and misleading statements as to his duties in order to avoid doing them, and when I called him to account, he just didn't respond ever again. I did present this evidence to the Federal Court of Appeal as they hear from the government on their appeal from the federal court decision that the government conduct was not reasonable, illegal, and unconstitutional, and despite David Lametti assuring the POEC inquiry that his legal advice to Cabinet was in good faith, they have refused to make that decision public. My evidence demonstrates that it was not in good faith, as he knew that he was in conflict with the Charter because he was refusing to respond to the enforcement procedure and knew accountability was being requested through constitutional questions and a writ of mandamus. In the current situation, I cannot access justice through the legal system, my Member of Parliament does not respond, and all other mechanisms of communications have been attempted. The last that I communicated with someone from CRA was Matthew Hopkins, who I had explained my position as he explained the legal action that the government was undertaking for failing to file income tax statements. In court, the judge refused to allow Mr. Hopkins to answer the question that I posed to him. What do you think of the fairness of a justice system that claims a judge can ignore the transcript to protect a lawyer committing fraud? We all know the answer to that question. Unfortunately, lawyers and judges are completely silent on the issue. When I was sent to jail after an unfair and partial trial that was certainly not complying with fundamental justice, instead was retribution for my exposing their crimes, as it was such a miscarriage of justice. I had challenged the constitutionality of the Judges Act, and they refused to engage. We declined to participate. Because my evidence demonstrated that no Canadians has any rights at all. Victim or perpetrator, mother or father, you are rats in a maze. And that is the access to justice crisis. Like a pyramid scheme, a shell game eventually is uncovered. But the legitimacy of judiciary has been questioned on several occasions, and they refuse to submit to legitimate review. The executive's conduct is being questioned by the judiciary. The judiciary always questions the legality of laws made by the representatives of the people of Canada, but now that questions as to the legitimacy of the judiciary and executive are being asked, the power of the legitimacy of the decision makers, the members of Parliament, is being questioned as foreign interference. Amidst questions regarding the process of Justice Brown's removal, the last Supreme Court of Canada's Justice appointed move the balance of judges in that forum in favor of the ruling party. As I noted in my appeal to the BC Court of Appeal, that if one cannot report a crime within a legal system, then there isn't any difference between that and a protection racket, except the legal system has captured the perceived legitimacy and coercive powers of the state. The highest court available to me stated that it is unclear to me whether Mr. Holsworth is intentionally ignoring the clear rule that judges must exercise their discretion judicially, and is so in doing so in order to obfuscate and delay the fact of his convictions under the ITA, or whether, that's the Income Tax Act, you might know that, or whether he actually believes he was unfairly treated in 2006 and is therefore somehow not bound by court orders or by the duty of all Canadians to file income tax returns. In any event, his leap from the fact that his evidence, she doesn't mention that it's a transcript, was not accepted in 2006, to the existence of a vast failure of the justice system and of lawyers and judges to comply with their oaths of office and codes of ethics, seems to indicate a disturbing world view rife with conspiracies and corruption. This does not reflect reality. The words, the transcript, are not included in the judge's decision, but as correctly inserted, it proves the existence of the corruption, denied in their reflection of reality. From prison, I appealed to the Supreme Court of Canada for the constitutionally guaranteed right to appeal by habeas corpus, a check on the legality of the imprisonment. I wanted to be sure that the highest court in the land had a chance to respond, but they denied, and only after calls by my father to the Canadian High Commission in Australia did a response arrive, terming my application a letter. The judiciary cannot justify their conduct in a free and democratic state, and neither can the executive. Parliament, representing the people of Canada, are the legitimate checks on the power of the executive and the judiciary. What does the public service say? Your governing institution, the legal system, arbitrator of the public with the public service, claims that the public has no rights, in particular the most important one, the safety of not being extorted by the state. What does the public service manual say? Values and ethics code for the public sector, respect for democracy. The system of Canadian parliamentary democracy and its institutions are fundamental to serving the public interest. Public servants recognize that elected officials are accountable to Parliament and ultimately to the Canadian people, and that a non-partisan public sector is essential to our democratic system. Respect for people. Treating all people with respect, dignity, and fairness is fundamental to our relationship with the Canadian public and contributes to a safe and healthy work environment that promotes engagement, openness, and transparency. The diversity of our people and the ideas they generate are the source of our innovation. Integrity. Integrity is the cornerstone of good governance and democracy. By upholding the highest and ethical standards, public servants can serve and enhance public confidence in the honesty, fairness, and impartiality of the federal public sector. Stewardship. Federal public servants are entrusted to use and care for public resources responsibly for both the short term and long term. Excellence. Excellence in the design and delivery of public sector policy, programs, and services is beneficial to every aspect of Canadian public life. Engagement, collaboration, effective teamwork, and professional development are all essential to a high-performing organization. One cannot be neutral in the face of oppression. It is time for the public service to speak. The Public Prosecution Service dropped their prosecution of my failure to file income tax statements in the public interest. That means that given the evidence provided, they did not feel they could justify the prosecution in the public interest. I requested for more details, but none were provided. The problem that I presented in court is that given that the judiciary claims that they can ignore all my evidence, there is no way that I can dispute the amount that the government claims I owe. Furthermore, I attempted to negotiate with the CRA and make payments using the method claimed to be fair and impartial by the judiciary. If it was fair to apply to me, it should be fair in return. In the In the divorce, the judge provided me with the assets of my bankrupt company that he declared had a share value of 0, but for the purposes of the divorce gave it a value of $295,000, the value in the shareholder's loan account. That was the money that I'd borrowed to start my company. That was what they gave me. But the company had no value, so it couldn't return it. I suggested that if it was fair for me, it should be fair in return. I would transfer the value in the shareholder's loan account to the amount owed to the CRA. Fair is fair. CRA did not accept my proposal, claiming that they did not understand. They only wanted cold hard cash, not equal treatment under the law. Please consider that the volunteer work that I have done in the promotion of the public interest, accountability, and the rule of law could be taken into consideration in our communication. Yours sincerely, Trevor Holsworth, www.fundamentaljustice.com. You can find all the links to all my arguments and the evidence on the website, including my application for intervener in the appeal by the federal government regarding their illegal and unconstitutional conduct in the enforcement of the Emergencies Act, because my evidence demonstrated that the Minister of Justice knew that the administration was not in compliance with the law and the public was not being protected, and that his conduct was not in good faith, as requests for accountability were on his desk and before the court, and his response made false and misleading statements as to his duties in order to protect his friends, federal judges, instead of his duty to the people of Canada. I haven't received a response.